$487,216. That's how much was gone. Not gone like a bad stock year, not gone like the market dipped and I panicked and checked my 401k one too many times. Gone like it never existed. Gone like 6 years of statements I'd been mailed, 6 years of year-end summaries I'd filed in a drawer in my home office, 6 years of a man named Gary Holloway looking me in the eye at our annual portfolio review. That's what he called it, a portfolio review, like we were two professionals discussing the state of my empire, and telling me everything was on track for retirement. I found out on a Tuesday. I remember it was a Tuesday because I'd taken a half day off from teaching to go sit down with a Medicare specialist because I was turning 63, and I wanted to understand my options before I made any decisions I couldn't undo. I brought my most recent account statement with me, the one Gary had emailed me a PDF of 3 months earlier, the one that said in bold at the top, total portfolio value, $612,340.18. The Medicare specialist wasn't the one who found the problem. It was her assistant, a woman named Priya, who was cross-referencing my Social Security estimate against my retirement assets to run a withdrawal projection. She asked me for permission to pull a real-time account balance directly from the custodian, not from Gary's PDF, but from the actual brokerage where my money was supposedly sitting. She typed in my account number, she waited, and then she turned her laptop screen toward me, slowly, the way you'd turn over a card in a game you already knew you'd lost. Account value? $14,038.02. I want you to sit with that for a second, the way I had to in that beige office with the fake ficus tree in the corner. $612,000, according to the man I trusted with my future. $14,000, according to the truth. He thought he'd gotten away with it. For 6 years, he'd gotten away with it. He'd built fake statements, forged my signature on distribution paperwork I never saw, and used my retirement, my actual, real retirement, the one I'd built up over 31 years of teaching high school biology, to fund a life I didn't even know existed. He was wrong that he'd gotten away with it. This is the story of how I found out, how I built the case that put federal investigators on his doorstep, and how I got almost every single dollar back, plus something he never expected to have to pay. This is the story of Gary Holloway and the 6 years he stole from Denise Whitfield. That's me. I'm Denise, and this is what happened. Before I go further, I want to say something to anyone watching this who has that pit in their stomach right now, the one where you're thinking about your own advisor, your own accountant, your own trusted family friend who handles your money. If any part of this story feels familiar, stay until the end, because I'm going to walk through the exact red flags I missed, the exact paperwork you should be requesting this week, and the exact questions that would have caught Gary Holloway in year 1 instead of year 6. Today's story is about greed. It's about betrayal by someone who sat in my living room and ate my banana bread while he was actively forging my name on withdrawal slips. And it's about what it actually takes, not what TV makes it look like, but what it actually literally takes to get every single dollar back from a man who thought a retired school teacher would never figure it out. If you're new here, I tell true financial fraud stories, the ones that don't get covered on the news because there's no shooting, no car chase, just a quiet man in a golf shirt with a CFP designation and access to your account number. If that's the kind of story you want more of, hit subscribe because there are more of these coming, and every one of them ends the same way. The person who thought they were untouchable finds out they weren't. Let's start at the beginning. Let's start with how a man like Gary Holloway gets access to your life savings in the first place. I need to back up, not just to explain what happened, but because I think the how he got in part is the part that will actually protect you. Con men don't usually kick your door down, they get invited in. Mine got invited in over a potluck dinner. In 2016, I was 52 years old. I'd taught high school biology in the same district in central Ohio for 26 years at that point. My husband, David, worked in facilities management for the county. We were not rich people. We were did everything right people, the kind who maxed out what we could into my 403b and his 401k, who paid off our mortgage 11 years early, who drove a 2009 Honda Accord until it had 240,000 miles on it, because why would you replace something that still works? By 2016, between my retirement accounts, David's, and a small inheritance from my mother, we had just over $540,000 saved. Combined with our pensions, we were on track, a real, credible track, the kind a fee-only fiduciary could have verified in about 20 minutes to retire comfortably at 65. The problem was we didn't know what we didn't know. Neither David or I had any real financial education beyond save your money and don't touch it. We didn't know the difference between a fiduciary and a broker. We didn't know what assets under management fees meant, or how a 1% AUM fee compounds over 30 years, or that there's a difference between a certified financial planner and someone who just calls themselves a wealth advisor with zero enforceable standard behind the title. We were, in the parlance of the industry that eventually ate us alive, unsophisticated investors. That's a real term. It shows up in SEC complaints. It's a polite way of saying easy targets who trust people. We met Gary Holloway at a retirement planning seminar at the DoubleTree off Route 33. One of those free dinner seminars where a financial advisor rents a banquet room, buys everyone a chicken dinner, and gives a PowerPoint about the 3 biggest retirement mistakes. I want to be very clear for anyone watching this. Those seminars are almost always a sales funnel. Not always a scam, but almost always a sales funnel. We didn't know that. Gary was in his mid-40s then, soft-spoken, wore a wedding ring, talked about his 2 kids in Little League, kept a photo of a golden retriever named Biscuit as his phone background and showed it to anyone who asked. He didn't do a hard sell that night. That was the first thing that should have told me something. The good ones never do a hard sell on day 1. He followed up 2 weeks later with a handwritten note, not an email, an actual note card saying he enjoyed meeting us and would love to do a no-obligation portfolio checkup whenever we had time. David and I talked about it over dinner and decided, why not? It's free, and it might be good to have a professional set of eyes on things. Here's where it gets important, because this is the part that repeats in almost every one of these stories I tell on this channel. Gary didn't ask for our money in the first meeting. He asked for our trust. At that first sit-down, he spent almost the entire 90 minutes just asking questions about David's job, about my classroom, about my mother, who'd passed the year before, and how I was handling the inheritance, about our daughter, Megan, who was in her 2nd year of nursing school. He took notes. He remembered details in follow-up conversations weeks later, the name of my classroom hamster, for God's sake. He asked about our fears, not our assets. What were we scared of? Outliving our money, being a burden on Megan, not being able to help pay for her wedding someday. I want to say something plainly because I think it's the most important sentence in this whole story. The men who steal the most don't look like thieves. They look like the person who finally listens. Looking back, and I mean really looking back, with the case files and the forensic accountant's report sitting on my desk as I write this, there were red flags stacked on top of red flags. I'm going to list them exactly as they happened because I promise you, if you're watching this and you have an advisor, you can check these boxes yourself tonight. Red flag 1, custody of assets. Gary told us that to streamline everything and give us one point of contact, it would be easier if our accounts were held with what he called his back office custodian, rather than directly with a major brokerage like Fidelity or Schwab in our own names with online access.
In reality, what he set up was a solicitor arrangement where funds were nominally held at a small regional clearing firm, but Gary's firm, Holloway Wealth Partners, which was really just Gary, a part-time assistant named Renee, and a rented office suite, had what's called trading authority and, we'd later learn, check writing and disbursement authority over the account. That authority came from a form we signed at that first real meeting, buried on page 6 of a stack of paperwork called a limited power of attorney. Red flag 2, no direct online login. We never had our own login credentials to see our real-time balance at the custodian. Everything came through Gary, every statement, every performance report. If you cannot log into your own account at the actual custodian with your own username and password that you created, that is not a minor inconvenience. That is the single most common structural feature of every affinity fraud and advisor theft case the SEC has ever prosecuted. Red flag 3, consistent, suspiciously smooth returns. From 2017 to 2022, our statements showed steady growth, 7, 8, sometimes 9% a year, almost no down years, even through periods when the market was genuinely rocky. Real diversified portfolios have bad years. Ours never did. When I finally brought this up to a forensic accountant years later, she said something I'll never forget. Fraudulent statements are always smoother than real ones. Real money is messy. Fake money is tidy. Red flag 4, he discouraged a second opinion. Twice over those years, I mentioned wanting to get a second set of eyes on our portfolio, once when a coworker recommended her CPA, once when Megan, by then working and reading personal finance content online, asked why we didn't just move to an index fund at Vanguard. Both times, Gary had an answer ready, fast, almost rehearsed. Anyone who doesn't understand our long-term strategy is going to scare you out of a good plan. He framed outside advice as a threat to our progress, not as due diligence. That is a script. It is a script that shows up nearly word for word in FINRA arbitration filings against dozens of advisors. Red flag 5, fee structure we never really understood. We signed a fee agreement for 1% AUM billed quarterly. We never actually verified that the fees being deducted matched 1% of our real balance because we had no real balance to check it against. We just trusted the number on his statement. Red flag 6, the personal relationship. Gary came to my retirement party at school in 2019. He sent a card when David's mother passed. He remembered our anniversary. This is not an accident. Every fraud investigator I eventually worked with told me the same thing. The personal relationship is not a byproduct of the fraud. It is the delivery mechanism for the fraud. The first real transfer happened in March of 2017. We rolled over my 403B, at that point about $310,000, into what Gary called a self-directed IRA under his firm's management, plus David's 401k from a previous employer, about $140,000, plus my mother's inheritance of roughly $90,000. All told, just over $540,000 moved out of accounts we controlled directly and into accounts Gary Holloway controlled the paperwork for. I remember signing the rollover forms at his office. I remember him saying, "This is the last piece of paperwork you'll ever have to sign for a while. From here, I handle everything." I remember feeling relieved, taken care of, like an enormous weight had been handed to someone finally qualified to carry it. That sentence, "I handle everything," is, I now know, one of the most dangerous sentences in personal finance, because for the next 6 years, he did handle everything, just not in the direction we thought. And that's when I found the smoking gun, except I didn't know it yet, because the smoking gun wasn't a single moment. It was buried in 6 years of statements that all looked correct on paper at a glance. It would take a woman named Priya, a Medicare specialist's assistant with 15 minutes and a login screen, to finally pull the trigger on the whole thing coming apart. But that's Act 2. Let's go back to that Tuesday. The Medicare office, Priya turning her laptop toward me. Account value, $14,038.02. I laughed. I actually laughed, the kind of laugh you do when your brain hasn't caught up to what your eyes are telling it. I said, "That can't be right. We have an advisor. He sends us statements. I have one right here." And I pulled out the folded PDF printout from my bag, the one showing $612,340.18. Priya looked at it, then looked at her screen, then looked at me with an expression I now recognize from every single person who has ever had to deliver this news to someone, a mixture of professional caution and genuine human dread. She said, very carefully, "Mrs. Whitfield, I'm pulling this directly from the custodian system. This is the real-time balance. I don't know what document you're holding, but it isn't matching what's actually in the account." I want to describe the physical sensation, because if you've been through something like this, you know exactly what I mean, and if you haven't, I hope you never have to. It's not like fear. It's like the floor tilts about 4 degrees and doesn't come back level. Your ears ring slightly. You hear yourself asking normal questions in a voice that doesn't sound like yours, asking, "Is there a chance it's just a different account number? Could there be a typo?" While some other, quieter part of your brain has already started doing the math and already knows. I called Gary that afternoon from the parking lot of the Medicare office. He picked up on the second ring, and this detail matters, so I want you to sit with it. He was calm, not confused calm, not "let me look into this" calm, a specific, practiced, reassuring calm, the same tone he'd used to talk me through a market dip. He said there must have been a reporting error at the clearing firm and that he'd get to the bottom of it first thing tomorrow. He said, and I remember this exactly, "Denise, I promise you, your money is safe. I would never let anything happen to your money." I believed him. For about 11 more days, I believed him. Over the following week and a half, I got 3 different explanations, each one slightly more elaborate than the last. First, a system sync issue between his internal reporting software and the custodian. Then, a temporary hold related to a supposed compliance review of his firm, which he framed as routine, even boring, the kind of thing that happens to advisors all the time. Then, when I pushed harder and said I wanted to see the actual account statements directly from the custodian, not from him, a story that some of our money had been moved into a private placement, a real term, by the way, one that legitimately exists in the investment world, usually referring to non-publicly traded investments sold to accredited investors, that was temporarily illiquid but performing well. That third explanation is when something in me finally, fully snapped into focus. Because David and I had never signed anything about a private placement. We had never been told our money left traditional liquid investments. And when I asked Gary to send me the paperwork for this supposed private placement, the subscription agreement, the offering memorandum, anything with our signatures on it, he told me he'd have Renee pull it together and get back to me. He never did. I'm going to give you the real numbers now, the ones that would later be confirmed dollar for dollar by a forensic accountant and later still by federal investigators. This is not an estimate. This is what the final restitution order says. Between March 2017 and the discovery in that Medicare office in 2023, just over 6 years, Gary Holloway diverted $487,216 out of our accounts through a combination of methods.
forged distribution requests, standard form withdrawal paperwork bearing what was later confirmed by a document examiner to be a traced or copied version of my signature, requesting cash distributions sent not to our bank account, but to an intermediary LLC account Gary controlled called Meridian Capital Advisory Services, LLC, a name deliberately close to real, legitimate-sounding firms designed to look unremarkable on a bank statement. Babacated statements. Gary generated our quarterly and annual statements using a template that mimicked the custodian's real formatting closely enough to fool a layperson, but omitted the custodian's actual verification footer and account verification QR code that real statements from that clearing firm included after 2019, a detail that, again, we had no reason to know to look for. Fee layering theft. On top of outright transfers, he charged management fees calculated against the fake, inflated account balance rather than the real one, meaning he was charging us 1% annually on money that, in some years, was already gone. We were paying him a management fee to manage a lie.
The emotional and relational damage doesn't show up in a restitution order, but it was just as real. David and I fought, badly, for the first time in almost 30 years of marriage, because in the early days of the discovery, before we understood the scope, there was a horrible period where each of us silently wondered if the other had done something with the money without telling them. That's what fraud does that people don't talk about enough. It doesn't just steal money, it plants suspicion between people who trust each other, because the human brain reaches for the simplest explanation, and "my spouse did something" can feel simpler, in the first panicked hours, than "a man we trusted for 6 years is a criminal." Our daughter, Megan, when we finally told her, offered to pause saving for her own wedding to help us. I had to tell my 30-year-old daughter that her mother, a woman who spent 3 decades teaching children how the world worked, had been fooled for 6 years by a man with a golden retriever background photo. That was honestly harder than the number itself. We tried to resolve this the normal way first, because that's what you do. You assume the system will help you. It mostly didn't, at least not quickly. We filed a written complaint with Gary's broker-dealer, a mid-sized independent firm that had licensed him as a registered representative, meaning Gary wasn't fully independent. He operated under an umbrella firm's compliance oversight, which is common in the industry and which most clients never think to ask about. The firm's compliance department sent a form letter acknowledging receipt and said it would conduct an internal review, a process they said could take up to 90 days. We called the custodian directly. They confirmed the real, current balance, that $14,038.02, but told us that because the account paperwork on file gave Gary's firm limited power of attorney and trading disbursement authority, from their perspective, this wasn't obviously theft. It looked, on the surface, like a client's authorized advisor moving the client's own money, which is legal and happens constantly in the ordinary course of business. That was the moment I understood something that changed how I approached everything from then on. Nobody in the system was going to prove this was fraud for me. I was going to have to prove it myself. I'll lay out in order the mechanics we later reconstructed, because understanding how he covered his tracks is exactly what let us uncover them. First, the statement mimicry. Gary used a document template, we'd learn, built off an old, legitimate statement from the custodian he'd altered in a PDF editor, updating the numbers each quarter but never actually pulling live data. It looked convincing because it was, structurally, a real document, just with the numbers hollowed out and replaced. Second, the redirect account. Meridian Capital Advisory Services, LLC, was registered by Gary in a different state, Delaware, chosen for its famously light disclosure requirements for LLC formation, with Gary listed only as the LLC's registered agent contact, not its owner of record, using a filing service that didn't require him to publicly disclose beneficial ownership at the state level. Money moved from our real account through this LLC and then onward. We'd eventually trace some of it to a personal account and the rest to purchases we'll get to in Act 4.
Third, and this is the one that made me the angriest when I learned it, Gary selectively timed disbursements to occur in amounts just under $10,000, spread out with irregular gaps, avoiding the round, memorable transfer sizes that might catch a client's eye during a casual statement skim, and, though we couldn't prove intent on this specific point without his internal records, avoiding transaction sizes that trigger certain automatic bank reporting thresholds tied to anti-money laundering rules. Structuring transactions to avoid reporting thresholds is, on its own, a separate federal crime. Fourth, he was selective and patient. He never took everything at once. He took enough at a pace slow enough that any single year's statement still looked plausible if you didn't compare it against the years before and after with real scrutiny. That patience is why it took 6 years. That patience is also eventually what gave us the paper trail to convict him, because patience means volume, and volume means evidence. I hung up the phone with the custodian that day, sat in my car in the school parking lot where I still substitute taught 2 days a week, and I made a decision. I wasn't going to wait for a compliance department's 90-day review. I wasn't going to wait for a broker-dealer to police its own registered representative. I was going to build the case myself, from the ground up, with every piece of paper I could get my hands on. And that's when I found the smoking gun. Not the whole case, not yet, but the first document that proved, on paper, that Gary Holloway had lied to my face. It was a single line item on a wire transfer confirmation the custodian's compliance department sent me after I formally requested, in writing, citing my rights under the account agreement, the actual unaltered transaction history for the prior 24 months. A disbursement of $22,400 dated 14 months ago, made out not to David and me, not to any account we recognized, but to Meridian Capital Advisory Services, LLC. We had never heard that name in our lives. I want to be honest about something. I am not naturally an organized person. Ask any student I ever taught about the state of my classroom desk. But something happens to you when you find out you've been robbed by someone who smiled at your dinner table. It rewires your priorities completely. I stopped grading papers I'd promised to have back by Friday. I stopped watching television in the evenings. Every night for about 4 months, from roughly 8 p.m. to midnight, I sat at our kitchen table with a legal pad, a 3-ring binder, and eventually a spreadsheet David helped me build, and I built a timeline.
The first rule I gave myself, which I'd recommend to anyone in this position, get everything in writing and get everything from the source, never from the person you suspect. Every email to the custodian, every request to the broker-dealer's compliance department, every conversation with Gary himself. I started recording in a one-party consent state, which Ohio is, meaning it's legal to record a call you're a participant in without telling the other party. Always check your own state's law before doing this, and following up every phone call with a same-day email that said, in writing, confirming our conversation today in which you told me X. That forces the other person to either confirm it in writing or contradict themselves in writing. Both are useful. Here is the actual sequence of documents I gathered, roughly in order, because I think the how here is more valuable to you than almost anything else in this story. 1. The full transaction history from the custodian, not the summary statements Gary sent, the raw transaction-by-transaction ledger going back to account opening in 2017. Under the account agreement, the custodian was required to provide this to me as the account holder within a reasonable time frame once I requested it in writing and cited my rights. It took 3 weeks and 2 escalation emails, but I got it. 2. Bank records for our own linked checking account. I wanted to see every deposit that ever came from the investment account into our checking account so I could compare what Gary told us we'd withdrawn against what actually arrived. Across 6 years, there were exactly 11 distributions we recognized as ones we'd actually requested and received, totaling about $61,000,
mostly for a kitchen renovation in 2019 and help with Megan's nursing school costs. Every other disbursement on the custodian's ledger, dozens of them, went somewhere else. 3. Ohio Secretary of State business filings. This one is free and public, and it's the single most useful tool an ordinary person has. I searched Meridian Capital Advisory Services, LLC, and found nothing registered in Ohio. I then searched Delaware's Public Business Entity Search, also free, and found it, registered in October 2016, 5 months before our first rollover, with a registered agent service listed instead of Gary's name. That timing detail mattered enormously later. The LLC existed before he ever pitched us the private placement story, meaning it wasn't a real, spontaneous investment vehicle. It was infrastructure, built in advance. 4. FINRA broker check. This is the single biggest resource most people never use, and it's free, public, and takes about 2 minutes. FINRA, the Financial Industry Regulatory Authority, maintains a public database of every registered broker's licensing history, employment history, and, critically, any customer disputes, regulatory actions, or terminations. When I pulled Gary's broker check report, I found something that made my stomach drop. A customer dispute from 2014, 3 years before he ever met us, at a previous firm, alleging unauthorized trading and misrepresentation of account values, which had been settled for an undisclosed amount with no admission of wrongdoing, and which Gary had never once mentioned to us. That report is public. Anyone can look up anyone. I hadn't known to check.
5. Social media and public records on Gary's lifestyle. This part felt uncomfortable to do, and I want to be honest about that discomfort. But a private investigator I eventually hired confirmed it was both legal and standard practice. Publicly viewable Facebook and Instagram posts, a boat registered in Ohio's public watercraft title database under Gary's name, purchased in 2019 for a price well beyond what a small independent advisory firm's legitimate revenue could plausibly support, and property records showing a lake house purchased in 2020 in Coshocton County, financed with what public mortgage filings showed as an unusually large cash down payment. By month 2, I knew I was out of my depth for the parts that required real financial forensics and legal muscle, so I did 3 things in fairly quick succession. First, I hired a forensic accountant, specifically someone with a CFE credential, Certified Fraud Examiner, which is the relevant specialty for exactly this kind of case, as opposed to a general CPA. Her name, for this story, was Marla. Marla's job was to take the raw custodian ledger, our bank records, and the fake statements Gary had sent us and produce a clean, defensible reconciliation showing exactly how much was diverted, when, and through what mechanism. This document became the backbone of everything that followed. The securities attorney used it, and eventually the federal prosecutor used a version of it almost unchanged. Second, I retained a securities fraud attorney who specialized in FINRA arbitration and advisor misconduct cases, working on a contingency fee basis, meaning she only got paid a percentage if we recovered money, which matters a lot because most people in our position, having just lost $500,000, do not have spare cash for a retainer. She explained something crucial. Because our account was held through a FINRA member broker-dealer, we had a path to recover damages through FINRA arbitration, a private dispute resolution process that most brokerage account agreements require instead of a public court lawsuit. And crucially, the broker-dealer firm that employed Gary could potentially be held liable for failure to supervise, even if the firm itself didn't directly steal anything, if we could show they missed red flags they should have caught. Third, on the attorney's recommendation, we filed a written complaint with the SEC's Office of the Whistleblower and separately with FINRA's Investor Complaint Portal, both of which are free, public-facing intake systems specifically designed for exactly this situation.
We also filed a police report with our local police department, and because the amount and the interstate nature of the LLC filing likely qualified it as wire fraud, our attorney helped us formally refer the matter to the FBI's field office and the U.S. Attorney's Office for our district. Here's the piece of this story that still gives me chills. About 6 weeks into the investigation, I got a message through LinkedIn from a woman named Renee, Gary's former part-time assistant, the one who used to send us paperwork. She'd left the firm in 2022 after what she described as a bad feeling I couldn't shake for a year. She said she'd seen my name come up in a local Facebook group for our town where I'd cautiously posted, without accusing anyone by name yet, on my attorney's advice, that I was looking to connect with anyone who'd worked with a financial advisor in the area and had unexplained account discrepancies.
Renee told me she'd once been asked by Gary to print a blank distribution form and noticed, months later, a completed version of that exact form with a client's signature that didn't look like it was signed in front of anyone, meaning it looked traced rather than freely signed. She'd also mentioned, almost in passing, that Gary kept a second laptop in his office that he never let her touch, and that he'd once, offhand, referred to the Meridian account in a way that made no sense in the context of the conversation they'd been having. Renee eventually agreed to speak with our attorney, and later with an FBI agent, on the record. Whistleblowers like Renee are honestly how a huge number of these cases actually crack open, not because investigators find the smoking gun in a vault somewhere, but because someone who was adjacent to the fraud finally has a reason or the courage to say what they saw. I have to tell you about 2 moments where this almost fell apart entirely. The first, about 10 weeks in, Gary reached out to us directly, not through any attorney, just a phone call, sounding for the first time genuinely rattled rather than smoothly reassuring, and offered to make things right personally with a lump sum of $150,000 paid over 18 months if we would sign a private settlement agreement and agree not to pursue any further action. Our attorney was extremely direct with us about what this was, an attempt to buy silence for pennies on the dollar before regulators or the FBI got fully involved, and almost certainly funded, at least partly, by more of our own stolen money or other victims' money. We said no. That was hard. $150,000 felt in that moment like it might be the only money we'd ever see again. Walking away from a guaranteed partial recovery to pursue a full one is one of the scariest financial decisions I've ever made, and I want to be honest that it is not automatically the right call for everyone in every situation. But our attorney's read, based on the evidence we already had, was that we had enough for a much larger recovery, and she was right. The second near miss came about 3 months later, when we learned through a public court filing in an unrelated small claims matter another Ohio family had filed against Gary directly, which Marla found while doing a routine public records sweep, that Gary had begun transferring the lake house into a family trust structure, naming his adult brother-in-law as trustee. Our attorney recognized this immediately for what it was, a fraudulent transfer, an attempt to move assets out of his own name before any judgment or restitution order could attach to them. She moved quickly to have our attorney, and soon after, federal investigators aware of this in real time, which became important during the asset forfeiture phase later. By the end of Act 3, here's where things stood. We had a forensic accounting report showing $487,216 diverted across 6 years, a public LLC filing predating our first rollover by 5 months, a former employee willing to testify, a documented pattern of attempted asset flight, and as of a call from our attorney on a Thursday afternoon that I will never forget, confirmation that the FBI's Financial Crimes Unit had opened a formal case file and wanted to interview us directly. And that's when I found the smoking gun that actually mattered most, the one that turned this from a really strong civil case into a criminal indictment. It came from Renee, a forwarded email still sitting in her old personal Gmail account from a year earlier, where Gary had asked her in writing to make sure the Meridian statements match what we send the Whitfields. Don't let the numbers get out of sync again. In writing, from his own email address, describing in his own words the exact mechanism of the fraud. Here's how it actually played out on 2 tracks running at the same time, because that's how these cases usually work in real life: one criminal, one civil, moving at different speeds. On the criminal side, roughly 5 months after the FBI opened its file, a federal grand jury returned an indictment against Gary Holloway on charges including wire fraud, 18 U.S.C. Section 1343, mail fraud, and investment advisor fraud under the Investment Advisor Act, along with a structuring charge related to the pattern of disbursements kept under reporting thresholds. The case was captioned, for the record, United States versus Gary Holloway, and it wasn't just about us. As the investigation widened, agents identified 6 other client households Gary had defrauded using nearly identical methods over roughly the same period, bringing the total alleged theft across all victims to just over $2.3 million. That number matters because it's a piece of this story I want to be honest about. I was not his only victim, and I wasn't even his largest one. There was a retired couple, a widower in his 70s, and a small family business's retirement plan, all caught in the same pattern. Learning that was, in some ways, harder than learning about my own loss, realizing how many other kitchen tables had their own version of that Tuesday in the Medicare office. On the civil side, our securities attorney filed a FINRA arbitration claim against both Gary personally and the broker-dealer firm that had licensed him, arguing failure to supervise, specifically that the firm's compliance department had access to red flags, irregular disbursement patterns, a prior customer dispute on his broker check record, statement formats that didn't match the custodian's actual templates, that a reasonably diligent supervision program should have caught years earlier. This mattered enormously for actual recovery because criminal restitution orders are notoriously difficult to collect in full. You can't get blood from a stone, and by the time Gary was indicted, plenty of the stolen money was already spent. The broker-dealer firm, by contrast, had insurance and genuine assets. Gary ultimately pleaded guilty to the core wire fraud and investment advisor crime counts as part of a negotiated agreement rather than going to trial, which is common in cases with this much documentary evidence because the paper trail we and the FBI had assembled left very little room for a viable defense. At sentencing, the judge imposed 9 years in federal prison, followed by supervised release, and ordered restitution of $2.3 million to be paid across all 7 identified victim households, allocated proportionally to each household's documented losses, meaning our share of the restitution order was calculated directly off Marla's forensic accounting report. Separately, our FINRA arbitration claim against the broker-dealer settled before a final arbitration hearing was needed, for an amount that, combined with the restitution and the asset forfeiture below, brought our total actual recovery to $471,900, or just over 96.8% of what was originally taken. I want to be honest about that remaining gap, because I think false promises of getting every dollar back, guaranteed, do a disservice to anyone going through this. We did not recover literally every single dollar, dollar for dollar. We recovered the overwhelming majority of it through 2 separate legal tracks running in parallel, and that took roughly 14 months from the day in the Medicare office to the day the settlement funds actually cleared into our new accounts. Accounts that, this time, I opened myself directly with my own login credentials at a large, well-known custodian with a fee-only fiduciary advisor I now pay by the hour instead of as a percentage of assets. Part of that recovery came through criminal asset forfeiture, the process by which the government seizes property that's traceable to criminal proceeds. Because federal investigators had been tipped off, thanks to Marla's public records sweep, to Gary's attempt to move the lake house into a family trust, prosecutors were able to secure a forfeiture order on that property before it could be fully shielded. The lake house, purchased in 2020 with what public filings showed was an unusually large cash down payment, and the boat, registered in the public watercraft database, were both seized and sold at a U.S. Marshals Service auction, with proceeds applied directly to the victim's restitution. Local news picked up the story once the indictment became public. Court filings and grand jury indictments are public record, unlike the earlier Compliance Department internal review, which had stayed quiet and unaccountable for months. A local television station ran a segment, and Gary's name and photograph appeared in coverage that, frankly, I take a certain grim satisfaction in, because for 6 years, his entire method depended on nobody outside his own client list ever hearing his name in connection with fraud. That anonymity is gone permanently now. Anyone who searches his name today finds the indictment, the plea, and the sentence. This is the part of the story that, honestly, took the longest for me to process emotionally, longer than the number itself. Through Marla's forensic tracing and later information that came out during sentencing, we learned where a meaningful chunk of the stolen $2.3 million actually went. Some of it, as you'd expect, went to visible lifestyle upgrades. The lake house, the boat, a couple of family vacations that showed up, ironically, in Gary's own public Instagram posts, geotagged and dated, which Marla had used as corroborating evidence. But a significant portion, investigators estimated somewhere around $380,000 of the total across all victims, had gone to online sports betting and options trading through a personal brokerage account, in what looked, from the trading records, like Gary repeatedly trying to win back losses from previous bad bets, digging the hole progressively deeper over time rather than in one deliberate theft. It wasn't, in other words, one calculated master plan from day one. It was, at least in part, a gambling problem that spiraled, where each new theft was partly an attempt to cover the last. Which doesn't make it less criminal and doesn't make him less responsible, but it did reframe the story for me from evil genius con man to something sadder and, in its own way, more mundane. An ordinary, undisciplined man who discovered he had access to other people's money and no internal mechanism to stop himself once he started. There was also, separately, an undisclosed second household, not a mistress in the dramatic sense you might expect, but a long-term relationship Gary had been financially supporting for years, including private school tuition for a child, which came out during the sentencing hearing's victim impact statements when his own wife, sitting in the courtroom gallery, learned about it apparently for the first time in open court at the same moment we did. I won't pretend I felt nothing watching that. There is a strange, uncomfortable kind of shared grief in a courtroom like that. His wife had also, in her own way, been living inside a version of events that wasn't true. Once the funds cleared, David and I made some decisions we should have made a decade earlier. We moved our money to a large, well-known custodian where I have my own direct login. We hired a fee-only fiduciary, meaning someone legally bound to act in our best interest, compensated by a flat fee rather than commissions or percentage tied to how much we invest, which removes the incentive structure that let Gary's kind of fraud and plenty of merely bad but legal advice thrive in the first place. We set a standing calendar reminder every single quarter to log in directly to the custodian ourselves and reconcile the balance against whatever report our new advisor sends, a 5-minute habit that would have caught Gary in his very first year. 14 months of nights at that kitchen table, a forensic accountant, a securities attorney, a whistleblower, an FBI financial crimes unit, and one Medicare specialist's assistant with 15 minutes and a login screen. That's what it took. Not luck, not a miracle. Documentation, public records anyone can access, and refusing to accept the first, second, or third explanation from the person who took our money. If you've made it this far, I want to leave you with the actual practical version of everything I learned the hard way, because that's genuinely the point of telling this story. Here's how to protect yourself. First, insist on direct, independent online access to your own accounts at the actual custodian, not just reports your advisor generates and sends you. If you cannot log in yourself with your own credentials, treat that as a 5-alarm fire, not a minor inconvenience. Second, run a free FINRA broker check search on your advisor tonight. It takes 2 minutes. Look for prior customer disputes, terminations, or regulatory actions, and ask directly about anything you find, because a legitimate advisor will have a clear, documented explanation, and someone hiding something will get defensive fast. Third, understand the difference between a fiduciary, legally bound to act in your best interest, and a broker, held only to a lesser suitability standard. Ask your advisor point blank, are you a fiduciary at all times, in writing? Get the answer in writing. Fourth, get a second opinion periodically, even if your advisor discourages it, especially if they discourage it. A confident, honest advisor welcomes scrutiny. Someone who frames outside opinions as a threat to your plan is showing you exactly what they're afraid you'll find. Fifth, watch for statements that are suspiciously smooth, steady, positive returns with no bad years, ever, even during periods you know the broader market struggled. Real portfolios are messy, manufactured ones are tidy. And finally, check your public records instinct. A business name you don't recognize on a transaction, a purchase that seems out of step with someone's disclosed income, a Secretary of State filing that predates a pitch you were given. These things are almost always publicly searchable, for free, in minutes. Most people just never think to look. I got my $612,000 back down to $14,000 and back up to a real, verified, independently confirmed $471,900 of recovered funds, plus a lake house and a boat that a criminal will never enjoy again, plus 9 years of Gary Holloway's freedom that he traded for 6 years of mine. Have you been through something like this? With an advisor, a family member, a business partner who had access to your money? I want to hear it in the comments. Tell me what happened. And if there's a detail in your story that matches anything you heard in this one, say so, because the more of these patterns we put on the record, publicly, the harder it gets for the next Gary Holloway to find his next Denise Whitfield. Subscribe if you want more of these. Every story on this channel ends the same way this one did. Thanks for watching, and take care of your money like someone is trying to take it from you, because eventually, someone might be.